Hi, everybody, and welcome to Raw Law. I'm Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome everyone. So today, I wanted to answer your questions. So if anyone is here and has a question about their personal injury case, they could drop it in the chat, and we could then analyze the question, and I could help answer it as a personal injury trial attorney in New York who has been practicing since 1999 for about 25 years now. So give you some answers and some experience. And we've also been doing another show called The Verdict, where if you give me a little bit of information about your case, such as the facts of what happened, the type of case, your injuries, your city, I could do a verdict search, and then I could answer through the verdict search and give you estimates as to other similar cases. For example, if you got rear-ended, right, in the Bronx, and your injury is a fusion, and you know that there's $1 million in coverage, right? I could do a verdict search and say, hey, these are the fusion verdicts for rear-end car accidents in this particular city. So I'm happy to do that as well. So let's see, we have some comments here. Bubakar says, hi, how are you? Good, everything is good. Been a little busy. Today was like a weird day. I had all these meetings, one after another, either meetings or some CLEs that I wanted to do, but it turned out well. Like I think it's necessary. And tomorrow is a different day. Tomorrow I don't have too much on the calendar. So if anybody needs a consultation, tomorrow is a good day for that. The calendar looks pretty open tomorrow. And It's Biggs says, good evening. Good to see you today. Oh, thank you so much. Great to see you as well. And Come Along with Uncle Joe says hello. Mr. Halloween says, hi, Mr. Arkady. Best lawyer in New York. Oh, thank you. And Come Along says, got notice that my deposition is in 3 months. Okay, that's good. 3 months. That's not so long. That's good. Yeah, get that deposition done. Make sure you get prepared for it so that it goes smoothly. That's very important. And James says, hi, how are you? And Zahanir says, hi, Mr. Frekhtman. I was in a MTA bus accident and I was taken to the hospital by the ambulance. I was wondering if getting the ambulance report from the FDNY would help with my case. Yeah, I mean, it does. You should definitely get it. I mean, you were in an MTA bus accident, and if there is an ambulance call report, you should get it. I mean, your lawyer should get it if you have a lawyer. If you don't have a lawyer, if you're trying to handle it on your own, you could get it as well. You just send the letter with an authorization, a cover letter saying, please be advised we are requesting the ambulance report, and an authorization, a HIPAA authorization signed that gives them the authorization to release your medical records, and then they will give it to you. And it should help with your case because it confirms that, it's serious enough to go to the hospital, to take an ambulance. The ambulance also has some medical information about, a lot of times at trial, lawyers, either for the plaintiff or the defendant, will look at the ambulance report, and then they'll start saying things like, oh, you're claiming a back injury, but look, in the ambulance report, you never said anything about your back. You only said it was your neck, right? Or vice versa. If it's like a plaintiff case, the plaintiff's attorney could say, look, you always complained about your left arm, and in the ambulance report, right when the ambulance came to the scene, right when the crash happened, you were complaining about left arm, and that's where you have the surgery. It's all left arm. It's very consistent, right? So either way, that's how it works. So, yeah. So I think you should, definitely get that. Definitely get that. That's just one of the pieces of the puzzle that you have to have. Yeah. So. And then let's see. So what other questions do we have? Paul says, thanks for your great advice and care for the average person. Oh, thank you so much. And Willie says, good afternoon, Mr. Arkady. Hi, how are you? I remember Willie, we spoke before. And D4 says, in LA, I was an Uber passenger hit and run, UIM, rear-ended, 1 epidural in the neck, 3 epidurals in the back, then a TDR, L4, L5, and L5S1 because the epidurals failed. Possible settlement amount, strong case. So yeah, so you're a passenger in an Uber and it's a hit and run. So you're going UM against the Uber, right? Uninsured motorist. So you have probably $1 million in coverage. And then with an epidural and then you said TDR. So I mean, yeah, it could be a big case. It's hard for me to say exactly, but like I would say a case like that. The only issue with UIM is you don't get a jury, right? Usually with UM, you have to go to the AAA and get an arbitrator. So it depends on what arbitrator you get, right? You get a cheap arbitrator, they might say, hey, I'm only going to give you like $50,000, right? Even though it might be worth a lot more. But if you get a good, fair arbitrator, then it might be worth even, maybe even like into the 300, 400,000 or more, maybe even much higher than that. So yeah, it could be a big case. And Bubakar says, in New York, can a case get a settlement after a deposition, and how long? Yeah, of course. I mean, that's usually when cases settle, right? Because the entire idea, the entire like theory or idea behind it is that, you could settle a case before a deposition, right? But the entire idea behind why most cases settle afterwards is because the deposition is your chance, right, to discover. That's why it's called discovery, right? It's like a chance to discover what happened, right? Because you say this is what happened, but the other driver, let's say if it's a car crash, says, no, I have my own story as to what happened, right? So you have two different stories. So now the lawyers are going to question all of the witnesses, whether they're the plaintiff, the defendant, the non-party witnesses, and they're going to have transcripts. They're also going to get medical records. So that's known as discovery, right? And after you discover what happened, well, now it's pretty clear as to what actually happened. Sometimes it's still unclear because the stories are so different. But at least like you have the basis, right? And if you go to trial, that's what you're going to argue is based on the evidence in the case, based on what you discovered in the discovery process. So that's like usually when the case is settled. And in terms of how long, I mean, it's hard for me to say exactly how long, because every case is going to be different. But a lot of cases settle after depositions when they're on the trial calendar waiting for the actual trial. That's when they'll settle. And then Sasha says, hi, Arkady. Dobby says, get better, Arkady. Okay, thank you. I'm always trying to get better. James says, hi, I spoke with you the other day. I'm just curious, if my lawyer served the insurance company, why did he tell how much and how does that work after they are served? So if he served the insurance company, I'm not sure I'm following the question, because like you don't usually serve the insurance company, you usually serve the defendant when you file a lawsuit, and then the insurance company just like answers the lawsuit. The only time you would have to serve the insurance company is if you can't find or serve the defendant, right? The defendant's like away, maybe they're in the military, maybe they're out of the country. Then you can file a motion for what's known as substituted service, and then the judge will say, okay, I'll let you serve the insurance company. So I'm not sure what you mean by serve the insurance company. And how does that work after they are served? Well, after the defendant is served, the insurance company then hires a law firm to defend the case, and that entails appearing in the case, right? Appearing means answering the lawsuit. So your lawsuit is your summons and complaint. You allege certain things like on or about X date, the defendant was negligent and this caused serious injuries. And then they appear and they answer, and the answer says, no, we denied this, we don't have sufficient information to form a belief as to number two, and every allegation you make, 1 through 50, they respond. Usually they just deny everything. And then you have joinder of issue, right? Because you filed a lawsuit, they answered the lawsuit, So now what happens is you go to a preliminary conference, and then the judge will give you an order to start discovery, what we just talked about. So that's usually how it works. And then Rick says, good day, Arkady. My question is, how soon do you think you'll have your next verdict search? Thank you in advance. Yeah, no, absolutely. I could do another verdict search video. We could even do some today. Like, I'm open to doing it. Just let me know. In order to do it, I just need to know the facts of the case, like a little bit about what happened, the type of case, whether it's like a rear end or a slip and fall on water, a little bit about, and then your city and then your injury, just like, one or two sentences. I could even run a few, like one or two today during this live. But I'll do a few verdict searches videos that I record as well. In fact, I was planning to record a few videos tomorrow because my calendar is open. So I was going to do a few tomorrow morning. And then, in terms of like the verdict search, just let me know what topics you want me to cover, whether you want me to cover like a specific topic like, fusions or traumatic brain injury or something else. But yeah, I'm happy to do those. I like doing the verdict searches. And Maquiavella says, good afternoon, Mr. Arkady. When is the favorite time for the defense to contract a private investigator to follow the plaintiff? Yeah, so that would be usually after your deposition, right? Because in your deposition, you testify. And if you say, for example, I can't do X, like I can't go to the store and pick up the heavy grocery bags and carry them. So then what they do is they hire the private investigator, he follows you to the store, he's sitting in the parking lot, he's videotaping you, from his car coming out of the store carrying the grocery bags. Now they're going to say, well, no, you're a liar because you said you can't do that. Look, we have a video of you doing that, right? So that's usually what you do. And Sasha says, I hope your day is going well. What does it mean when the ambulance report says mechanism of injury is blunt trauma? Right. So blunt trauma usually means, that it's traumatic, that it's something like a blunt object hits you. So kind of like blunt trauma could be a fall where you hit your head, or it could be a car crash where you also hit your head either against the side of the car or the steering wheel, right? So it's going to be like traumatic, meaning not from degenerative changes like living your life, but rather through trauma, which is what you want, right? That's a good thing for you because as a personal injury plaintiff, you want it to be from the traumatic event, right? From the accident. So yeah, usually it's like an impact, and it could be penetration to the body. That's usually what they refer to. So yeah, I mean, I think it could include car crashes. It could also include other things like other mechanisms, but yeah. So that's usually what you see on an ambulance report. And Come Along with Uncle Joe says, can you do a verdict search in Compton, California for a trip and fall? Yeah, sure. I can do that. Yeah. So just give me the county. Is Compton Los Angeles County? I'm not sure, the county. And also give me the injuries. Because remember, verdict search, I mean, trip and fall, that would be under premises. So I could do that. But I would also need to know, the injuries. Otherwise, you just get every trip and fall case. It would be, I don't know if that would be helpful. And Zahanir says, my MTA bus accident case is being handled by your law firm, and I sent attorney Kevin an email regarding the medical document from the ambulance FDNY, but I haven't heard back from them yet. Yeah, that's okay. I mean, if you send him an email, we always know to get the FDNY report, of course. So yeah, we're going to get that, and it's going to be that's helpful to get. But you also have to get your medical care. Don't think that you just because you had an accident, right? If you had an accident, you go to the hospital or you go the FDNY, the ambulance comes. That's just like one day, or sometimes they just see you for a few hours. That's it, right? But then you have to start physical therapy, doctors, MRIs, and then if the doctors recommend like surgery, it's the whole product. You need everything, the whole medical treatment. It's not like the ambulance is gonna really be the end all. And Mr. Halloween says, I went to the hospital after 2 weeks. I thought I have minor muscle strains, but day by day, my symptoms have become severe. Can this impact my lawsuit? Yeah, of course. I mean, that's the whole point, right? If you have a permanent injury, you have to get a diagnosis. A diagnosis is basically when the doctors tell you what your injury is. And if it's permanent, that makes it a big case, right? Because it's a serious, life-changing, like forever injury, as opposed to having like, a little boo-boo. I get a boo-boo. Okay, I got a boo-boo. It hurts. Oh, now it's gone away. Okay, what's that worth? Okay, it's worth whatever, $10, right? It's not worth much. So that's the whole point, right? If you have just a minor muscle strain, it's not worth much. But if you have severe symptoms and they're permanent and you have that diagnosed by a doctor, that's where the big money comes in, like hundreds of thousands or even millions. And then Sasha says, what is the significance of blunt trauma notation? Well, it just means that, it was like a penetrating object or it was a force, right? And if you have blunt trauma, that's a good thing in terms of, proving causation. Because one of the things you have to prove is that, I don't know it would help if I knew what your case facts are, right? Because it's kind of hard to talk about it in a vacuum like that. But if you tell me what your case facts are, then I could tell you how it would be helpful or, I don't think it would hurt, right? Because usually blunt trauma just means that it happened due to an accident, right? Due to trauma, as opposed to from living your life or something else. Like, I think the definition is an injury caused by like a force or an impact. And, so usually it's when something collides with your body, when your body comes into contact with something. So like I said, it could be a car crash, trip and fall, anything like that. So that's usually helpful. And then Kite says, I live in California and had a slip and fall at my apartment where the apartments hired a paint company to paint the floor outside of my apartment door. They didn't give me notice, and the painters did not put. What happened? Sorry. Did not put up any caution tape or signs. I am suing the apartments and paint company. I had multiple cortisone injections in lower back and neck, multiple ablations in neck and back cortisone, and PRP injections in the knee, and an arthroscopic surgery in the knee. How much do you think my case could be worth? This happened in January of 2023, and I have a mediation scheduled in April. Mm-hmm. Okay, so you're in California, it's a slip and fall, and the painters didn't tell you that they were going to do anything, right? So, like, what did you trip on? You tripped on the paint, they left paint, and then your injury is cortisone injections, ablations, and platelet-rich plasma, right? PRP injection, and an arthroscopic surgery. Yeah, that could be worth significant amounts. Arthroscopic by itself could be worth like 150, 200, maybe even more than that. Then you also have the PRP and the ablation. So I would say it could be like 300 to 400, maybe more than that. So it could be a significant case for sure. I'm not sure I'm following the liability. I understand what you're saying, like the painters were painting the floor outside of your apartment and they didn't tell you, right? But then they didn't put any caution tape. But then it just says you're suing them. But what happened? That's so it's like you don't want to skip that. You want to like, the key thing is what happened. Like, did you trip on paint? Did they leave wet paint and you tripped on wet paint? But let's assume that you did. That would be a good liability because if they're painting outside your door, they should let you know, hey, we're painting here. Don't come outside. Are you okay not to come outside for the next 2 hours until the paint dries or whatever? They can't just, go ahead and do this and you don't know, right? You just open your door and go for a stroll. All of a sudden you have wet paint. That's a good liability case. Yeah, the damages are pretty significant. So I would say from 300 to 500 usually, like in that range. That's probably what it's worth. And Leonardo says, hello. Hi, how are you? And Money Dog says, how can I proceed with my personal injury case by representing myself against the defendants? They keep pushing the case further out. I would like a jury trial. Mm-hmm. it's hard to do it yourself. I mean, it's always better to hire a lawyer, but if you're going to try to do it yourself, just the same as what a lawyer should do. Just keep on them. Just say, look, we have court order deadlines. I'm a pro se litigant. You can't take advantage of me. Write to the judge and just say, look, I want dates. I want to, why are we adjourning this? This is a court order. This isn't an invitation to a cocktail party where you could say, no, I don't want to go. This is a court order. So let's go through and let's get this done. So, and then Alex says it's been over a month and a half since my lawyer requested a preliminary conference and still nothing yet with the other two defendants. Is this normal in Brooklyn? Yeah, I mean, like, Brooklyn actually is not bad. Brooklyn has been pretty quick. Manhattan, I think, has been the place where people have been waiting like 6 months to get a preliminary conference. I'm not familiar with Brooklyn being delayed. So he's waiting for a preliminary conference. It's been 2 months, a month and a half, right? And you're saying still nothing with the other two defendants. Do you mean the other two defendants haven't appeared in the case? Because, usually you move for a preliminary conference when everybody appears. So if you have, like, say, 3 defendants or, whatever number, 2 defendants, 3 defendants, you have to wait until all of them appear and answer, and then you move for the preliminary. Otherwise, you get a conference, right? You have discovery, but then the other guy hasn't even appeared. So that doesn't work. You'd have to wait for them to appear. I don't know if that's what you mean. But yeah, I mean, waiting a month and a half, that's normal, 2 months. But you should get it pretty soon. If you don't get it, you could always call. You could send an email, a letter to the court. But Brooklyn, from what I've seen, has been okay. And then Dobby says, seems like you have a cold. That's why I said feel better. Oh, no, I'm okay. I feel pretty good. Maybe I just a little, I don't know. Maybe I need to drink a little more water. And I feel okay. I'm not sick. I feel pretty good. I also think happened with my camera. I think the settings are a little off. So maybe if I look a little pale, it might be the settings. Because at one point I was doing all these meetings on Zoom and Gmeet, and I was like red, but I'm not, I'm not red. I'm not like, so I think and then I tried to change the settings, and maybe I put them too much to the other side. I need a tech person to come help me. I'm not so tech savvy. So now maybe I'm too pale. I don't know. I have to fix the camera. But no, I feel good. And then Ricey says, hell yeah, bro. Nice info. Just got out the depot. Went great. Oh, that's awesome. That's awesome. I'm really glad to hear that. And Dobby says, what is the value of a thoracic medial branch block? Yeah, so medial branch blocks, I mean, in my experience, they don't have too much value by themselves, right? Usually they're done with something else. Like, for example, if you have an epidural steroid injection, that has some value, but not great. Like, people usually get 20, 30,000 for that. Now, with the most I think I've ever gotten is like 140, 150 for an epidural. Medial branch is like those little nerves, right? Because an epidural is meant to alleviate the pain for the big nerves, but the medial branch nerves are really little. And so they do some branch blocks. I mean, those are more like just like to help you feel better. I've never really heard of anybody getting a big verdict just for medial branch blocks or a big settlement. But, like, you have to take it as one piece of the puzzle, right? And when you do that, in addition to like having a herniated disc, or having a bulging disc, or needing, an ablation, or needing a percutaneous discectomy, and then you also have the medial branch, it just kind of plays a role. So so I don't know if I'm explaining it correctly, but so it doesn't really have a value in and of itself, but it's like part of the process. It's like a step in the process. It's kind of like if you're trying to cook, I don't know, make something, right? You're trying to cook some kind of meal. So you might say, I'm trying to cook, I don't know, like pancakes, for example, right? So you need to get the flour, you need to get the eggs, you need to get some kind of water or milk. So it's just like one step in the process. You need that if the doctor thinks you need it, but it's not going to give you much value by itself. And then Lily says, please a verdict search on ulnar cubital tunnel surgery in Georgia and settlements. Okay, sure. Yeah, let me try to run one now. Actually, let me see. Let me do some. So I said I was going to do. I haven't even done one yet. So I don't want to be a liar. I got to do at least one. Okay, let's see. So we'll log into one of these databases like verdict search, and we'll go to Georgia. I mean, we could do the whole state, and if there's too many results, then we could also do a county in Georgia. And then I guess we'll just type in cubital tunnel. Cubital tunnel surgery. Actually, look, cubital tunnel surgery in Georgia, in the whole state, only has 2 results. So it's not that many. The first case looks like a Starbucks customer struck by an out-of-control SUV sued the driver, and that was in Forsyth County. And there was a cubital tunnel syndrome in the elbow, and there was a surgery. There was also a diffuse axonal brain injury, so there were other injuries. And there was a discectomy as well. And it was a motor vehicle case. And it happened in 2011, where somebody was sitting in a Starbucks coffee shop in Cumming when a sport utility vehicle plowed through the window, causing injuries. So that's like, I mean, that's a crazy liability case, right? You're sitting in a Starbucks, the car comes through the window, hits you. That's insane. And then the injuries were, there were disc herniations at C6, C7. There was a diffuse axonal brain injury, like we said. And then in the left non-dominant arm at the elbow, there was an ulnar decompression and cubital tunnel release with anterior transposition of the ulnar nerve, so surgery. And the result was that the parties agreed to a settlement, and it was for $1,325,000. So not bad. And Allstate tendered a $25,000 policy. USAA tendered a $300,000 policy, and then State Farm agreed to tender $100,000 and also to pay $900,000 outside the policy. So I think that might have been a bad faith type case, where they opened up the policy, because $900,000 of the $1.3 million was outside the policy. So why would they pay that unless, the plaintiff's attorney might have set it up properly, like I talk about in my videos, where you say, hey, pay us X. If you don't, it's going to be more. And actually, I think I know the plaintiff's attorney in this case. Yeah, I think I've seen his name. He's a good attorney. Yeah, I think let me see if it's the same person I'm thinking of. But yeah, I think he's a pretty good attorney. And I think he's out of Atlanta. He's a pretty good attorney. He knows what he's doing. He's a trial attorney. And I think that's him, right? So yeah, he's the one who got the case. I think I've heard his name, or I've met him maybe at some of these trial lawyer events that I'm going to. So that's one. And then the other case actually is a case where the other case is in Fulton County, Georgia, elbow injury, neurological thoracic outlet syndrome. And so a plaintiff was traveling in the left lane of a multi-lane roadway. The other case is from 1999, so it's a while ago. And so the plaintiff is traveling in this roadway, and then he attempts to pull into the left lane behind, the defendant attempts to pull into the left lane behind the plaintiff and strikes the right rear portion of the plaintiff's car. And the plaintiff developed numbness of the arm and clawing of the hand post-accident, and he was ultimately diagnosed with thoracic outlet syndrome and cubital tunnel syndrome. And at the time of the accident, the defendant was operating a van for his employer, which was an Omega house cleaning service company. And so the plaintiff alleged the defendant was negligent. The defendant said that the plaintiff returned to work immediately after the accident, and the plaintiff's ongoing arm problems were related to a subsequent water skiing accident. Not this, but afterwards the guy had a water skiing accident. That's where the elbow and the hand issue came from. And the injury was a neck and back pain, thoracic outlet syndrome, cubital tunnel syndrome, Plaintiff's injuries resulted in tingling and numbness in the right hand and clawing of the fifth finger of the right hand and required 2 future surgeries. The plaintiff claimed $14,000 in past medical specials and $35,000 in future medical specials. And so the result, let me see, the result was a verdict for the plaintiff, but it wasn't very good. It was $15,156. The jury gave $5,156 for past medicals and $10,000 for pain and suffering, and that was it. So I guess, that didn't. Maybe they believed that it was from the water skiing or. So you see the 2 cases, but they're so different, right? What is 1.3? What is 15,000? So it just goes to show. So it's hard to predict. It's not an exact science. This whole law gig, law world. It's not an exact science. Okay, and Canada says, hello, my attorney said my case settled 2 months ago, but I have not signed any documents. Is that normal? I mean, it could be if they're still waiting on something, like trying to work out your liens or waiting on something. It could be, you have to ask your attorney. Usually, if you settled it, if it's all resolved, they should be able to get you a release and be able to get a settlement going. And then James says, yes, he served a stop for my slip and fall, is what I meant. And what happens now that they were served? Oh, okay, he served the stop. When you say the stop, I'm not sure. So the slip and fall, he served the defendant. So like I was saying before, if he served the defendant, what happens is the next step is they appear in the case and you have the lawsuit going. And then Come Along with Uncle Joe says, Los Angeles, California, Compton, torn labrum surgery, rotator cuff surgery, 7 holes in the shoulder, 3 shots in the shoulder, 250 physical therapies over 3 years. Oh, wow, I'm sorry to hear that. Yeah, let me do a quick search for you. Let me see. So we'll go to California. We'll go to California. Reset everything so everything is clear. Then we'll go to California. We'll go to Los Angeles. And then we'll go to, and then you said the injury is torn labrum surgery with a rotator cuff. Well, let's just say it might give me, they have a drop-down list with under shoulder. Let's see what it has under shoulder. It has, oh yeah, it does have a rotator cuff with a tear. We could click that. I don't know if it has, but it has surgery under shoulder. Arthroscopic probably, right? It's not arthroscopic surgery. And then let me see, what else does he say? Arthroscopic surgery, rotator cuff surgery, 7 holes in the shoulder, 3 shots in the shoulder, 250 physical therapies over 3 years. I mean, I could put torn labrum too, or just labrum, that it's a labrum injury. Yeah, I mean, if I put all that, I get 18 cases, and they kind of run the gamut. I mean, but let me see. I'll sort them by date so you can see what's most recent. The most recent one is where a cyclist was struck by a truck while merging onto the street, and there was a torn labrum there, and it ended up being a $2.6 million verdict. So, I mean, there were probably other injuries too. There were some neck injuries and some traumatic brain injury. There was a fusion. So, sometimes it's hard because you'd have to isolate the injury and say only like the shoulder. But sometimes you get other injuries thrown in. Here's a case: right shoulder's injuries all due to the vehicle accident. This one was from 2024. And this was kind of more similar. There was a slap tear, physical therapy, comminuted fracture, displaced fracture, rotator cuff injury with supraspinatus muscle tendon tear. And this one was $2,045,000. And it was it happened in 2018. Somebody was driving a motorcycle near Redondo Beach, and as he entered the intersection of Artesia and Fulton, a vehicle driven by the defendant attempted to make a U-turn. So a motorcycle against a U-turn crash, and those were the injuries. And we can even look more specifically at the injuries. But basically, that's what it is. You know, like there was an MRI. There was treatment, also physical therapy, like you had, and there was a superior labrum, a slap tear, and a rotator cuff tear. That was one of the injuries. So that was $2 million. So yeah, and it broke down like 73,000 past medical costs, 71,000 future medical costs, 1 million future pain and suffering, 900,000 past pain and suffering. And so the total was $2,045,371. It was a 5-day trial with a 1-day deliberation. The jury vote was 9-3 on expenses, 10-2 on future medical expenses, 9-3 on past medical expenses, 12-0 on past pain and suffering, and 10-2 on future pain and suffering. It was 2 male and 10 female on the jury. And the post-trial motions, there were some post-trial motions because of a 998 demand. So because of that, I guess they beat the 998, which is like an offer of judgment. And so there was an additional $900,000 that they would owe. So almost $3 million. Yeah, so there's a few cases here. I mean, you know, I see some cases. Actually, like this third case, I know the lawyer is actually a lawyer I work with out in LA. He's a really good lawyer. He got almost a $7 million verdict. And it was a labrum tear. Oh, but this is a labrum in the hip, so it's a little different. But yeah, he got almost $7 million against Uber. Yeah. He had a $15 million demand and a $1 million offer, but he went to court and he got almost $7 million. And then, yeah, there's going to be a lot of different cases. The issue is that, like I said, right, it's hard to isolate. Like, so you'd have the labrum tear, but then you also have other injuries. And so because of that, you know, here's one for $46 million, but there was a labrum tear, there's a brain injury, there's a nose fracture, speech issues, mental, psychological, depression, you know, so then I think most of the money was for the other stuff, probably not. But the labrum tear by itself with surgery can be worth, it's definitely has value, but you know, usually maybe a few $100,000 if that's the only injury. If it's real serious and you can show it's life-changing, it could even go into the millions. I think there's, like you said, 7 holes or anchors and all these things. Could make it more. Okay, and then Sasha says, can the blunt trauma cause degenerative changes? Could you speak more about degenerative changes after blunt trauma, or could shed some light on the subject? No, the blunt trauma wouldn't cause degenerative changes. Degenerative changes are like the changes you get from the normal aging process, right? So like, imagine a baby is born, right? It doesn't have any degenerative changes, so it's just born. But as a person ages, as they become 20, as they become 30, 40, you know, it's a normal aging process. And you have things like degeneration, that your body degenerates from the day you're born up until the day that you die. So that's always the defense's argument. So if you say, okay, I got into a car accident, I had blunt force trauma, meaning my head hit the windshield, and that's why I have a brain injury, they'll say, no, it's from the normal aging process. So essentially what they're saying is, even if the car accident didn't happen, you would still be in this condition because you're just living your life, basically. So, but like I said, like if you have blunt force trauma, that, and you're a plaintiff and you're suing, it's a good thing, right? I mean, not good, you don't want to get hurt, but good in the sense that it's good for your case. It's in line with what you want to be able to prove your case. But yeah, it's not, it doesn't cause degenerative change. Degenerative changes are just caused by living your life. They're very slow and they're painless, and they just happen. Like, for example, sometimes people have certain changes in their discs, and those things are not known not to be caused by like a car accident or a slip and fall or any kind of traumatic event or accident, but rather by the normal painless aging process, right? Like sometimes you have that spondylosis, a little like ridges, and that's just known that happens. That's degenerative, for example. Okay, and then MMB says, if you had to estimate a rear end verdict where the plaintiff sustained an L4, L5 laminectomy with a right shoulder arthroscopic surgery with 3 injections, what would that be? So a rear end, and then it's an L4, L5 laminectomy. I mean, the laminectomy, that's a big one. I mean, I had some laminectomy trials. We ended up doing well at 1.6 million. And you also have the arthroscopic, right? So then, arthroscopic would probably add another 200,000-300,000 on top of it. So if you figure the laminectomy is from 1 to 1.5, maybe even 2 million, and then you have another 300,000-400,000. So yeah, altogether it could be anywhere from 1.5 to 2 million or more if the insurance is there, depending on of course where you are and how you present the case, who prepares it, if they're like ready to go to court. Settlements are usually less than trials, but if you have a real trial lawyer and they're preparing it, it could be big. It could definitely be big. Yeah, absolutely. I don't see any real issues with it. I mean, that sounds like a good case. And Sasha says car accident rear end. Oh, that's with the blunt trauma. I mean, like, I don't know what your injury is, but I wouldn't really worry about blunt trauma. I mean, blunt trauma, just like I said, it just means basically that it was a force, like something hit you. So if you're trying to prove it's from a car accident, then obviously something hit you, right? You got into a car accident. So that's all it is. It's consistent with a car accident. It makes sense. If it said degenerative in the hospital record, that would be bad, because that's the normal painless aging process that occurs like slow and chronic. That's not from any traumatic event. And Sandy says, good evening, Arkady, how are you? And Come Along says, chipped front tooth and strained muscles from pelvis to spine. Yeah, no, that could be added a little value as well. And Kite says, yeah, slipped on wet paint. That's the one we did before. Okay, that makes sense. Yeah, I think that's a good case that Kite has. That's a strong case for sure. And the Machine says, hi, Mr. Arkady. My trial date is coming soon, but I have lower back surgery pending approval. What happens if the surgery takes more than usual to get approved by the adjuster? Should we reschedule? It just depends. If you want to do the trial without the surgery, you could just say, I have medical need for the surgery. I'm going to do it. Look, I'm waiting on my approval, and just do the trial with a medical need for the surgery without actually having the surgery. It'll still add value, but probably not as much as if you had the surgery before the trial. And then if you don't want to do that, right, and the other option would be have the surgery, wait for the approval, tell the judge, hey, I need a little bit of an adjournment. Approval shouldn't take too long, like maybe like a few weeks, months, and then do the trial with everything done. And then Mr. Halloween says, Mr. Arkady, I had a work injury, floor collapse, but I went to the hospital 2 weeks after. I thought my injuries are just some muscle strains, but they became worse. Then I went to the ER 2 weeks later. Oh, I see. But then after that, I was diagnosed with a herniated disc, which I did surgery months after, shoulder rotator cuff surgery. My question is, the first I've seen a doctor was 2 weeks after the accident. Can the waiting time of 2 weeks weaken my personal injury lawsuit I'm also on workers' comp, 100% disabled. My boss also confirmed my fall to the workers' comp. No, I mean, I don't think that would really hurt you. You just have to explain it. If you had a work injury like that where the entire floor collapsed, and then you just went to the hospital 2 weeks later because, you thought, well, I'm hoping this is going to go away, even though like the floor collapsed, you fell. It was a serious incident, obviously, right? But you thought, hey, maybe this is going to go away. You want to be, thinking on the bright side, it's going to go away. My injuries are going to go away. That's fine. And then when you felt like, okay, no, I tried living pain-free. I tried to go back to work. I tried to give myself a chance to heal. I tried to go back to work. But like 2 weeks went by and I'm still in pain. I can't do anything. So what am I going to do? I have to go to the hospital now, right? It's like they forced you to go to the hospital. So I think that's fine. You just have to like frame it in the right way, right? Because what they're going to say is, oh no, they're going to frame it a different way. They're going to say, you weren't really hurt. If you were really hurt, you would have gone to the hospital right away. Why did you wait 2 whole weeks? That's 14 days, But I mean, you have serious injuries, so you just have to show it's just because I was hoping that it would go away on its own. It just depends on the type of person you are. Some people run to the hospital right at any little thing, and some people think, look, I understand this happened. Maybe it's going to go away. So it's reasonable, I think. You just have to frame it correctly. But yeah, if you need a consultation about that, just text me, 347-566-9595, and I'd be happy to, get more details from you and give you my opinion and give you some advice. And then Kite says, they left leg pain on the floor and I slipped on leg pain, have a video. Okay, yeah. Kite, I think, has a good case. That's a strong case. I think that's a slam dunk liability. And so we did Mr. Halloween. Let's see. Oh, here's a question. I had a hand tear in my right hand and 2 herniated discs in my back. If the discs healed, could I still get a $100,000 policy? Took almost a year and therapy and multiple epidurals. Yeah, I mean, I think so. If you have a hand tear, so it's a ligament in your hand, and 2 herniated discs in the back, you could potentially get 100,000 or maybe close to it. If you have to have physical therapy, you have to have epidurals, depending on where you are also, because some places people are suing for like medical bills in addition to plus wages, plus future medical expenses. When you add up all those elements of damages, it's pretty easy to get to 100,000. It's not that much money. And Paul says, Arkady, if I drive a medium-sized bus and leave snow on my roof and it falls on a vehicle and causes damage to a vehicle and injury, am I liable or my company I work for? I mean, the insurance will be for the company that you work for, so they'll be sued. But you might be sued too if that's what happened, because you're the employee who did it, right? And you might get in trouble with your employer. But I would think you wouldn't be sued personally, right? Because it's if it's a bus that's your employers, your boss's company bus, they would be the ones who would be sued, and it's their insurance. And the machine says, yes, looks a little blurry on the video. Yeah, I gotta fix that. And Alex says, everyone has appeared and answered the lawsuit, and there is a judge assigned. Could it be defendants delaying it when we are still waiting for documents from them? So if everyone appeared and there's a judge, then no, they should just give you a preliminary conference. I don't know what kind of documents you're waiting on from them, but it shouldn't really, they can't really delay a PC. A PC is just like automatic. They just give you a conference, you go, and that's the first meeting, and then they give you a schedule for doing everything. So no, I don't think they're gonna delay that. Okay. Probably have to run pretty soon. Let me try to get a few of these questions done quickly. Sade says, hello, I've had 6 surgeries, 5 injections. What do you think my case may be worth? Injured since 2022. I mean, look, 6 surgeries. I'd have to see what kind of surgeries, and I don't know what happened, right? How your accident happened, how much the insurance is, or where you are. it's kind of hard for me to, give you a value just based on that. But, 6 surgeries usually is worth a lot, at a few $100,000 or even into the millions if the insurance is there. But feel free to text me, 347-566-9595. I can even do a consult maybe tomorrow. And it's free and confidential, and I can give you much more information. And then Cash says, hi, I'm in Georgia. I was rear-ended back in May. Today I answered discovery questions. What happens next, and how long should I expect it to take? So if you get rear-ended and you're answering discovery, probably the next step would be depositions. And then, it's hard to say because it could settle during depositions, it could settle after depositions. So I think you should ask your lawyer, how long they think. But it's hard to estimate exactly how long. But yeah, I mean, it shouldn't be. It sounds like it's moving in the right direction. And then Robin says, can my lawyer send me my settlement if I am in the next country? You mean if you're in a different country? Yeah, they can just put it in your account. And then Maddie says, do I continue going to my doctors after the lawsuit was served? And do I keep sending the paperwork to my attorney, even if I'm done with surgeries? I had 2 cervical fusions, rotator cuff, bicep tear. Yeah, you definitely want to continue going to the doctor. Just because the lawsuit was filed and served, that's just the beginning, right? So imagine you file a lawsuit in court, you serve a lawsuit on the people you're suing, and then you stop going to the doctor. But the case might take another 3 years, and then they'll love that, right? Because they'll come to court and they'll say, look, this guy hasn't been to the doctor since before this lawsuit has even started, right? You have to keep going to the doctor all along because that shows that you have a serious, life-changing, permanent injury. So yeah, definitely go to the doctor. That's like the most important thing. Don't stop going to the doctor. And then Willie says, thank you, sir. I really appreciate this. Oh, you're very welcome. And Take Hizzy says, online my case says ADR workflow in April 12th. Could I settle soon if I haven't had my depo yet? I've been in 2 crashes, one in 23 and recently around October of 24. ADR workflow. I'm not sure what ADR, I mean, alternative dispute resolution, I guess. They're trying to resolve the case. I mean, it could settle, yeah, sure. You don't have to have a deposition for a case to settle, but it's just more likely to settle after a deposition because everything's already been done and they know, because the insurance companies aren't going to pay big money unless they've even spoken with you, right? They want to be able to question you, make sure you're credible, make sure your story makes sense, there's no holes in your story, see what kind of person you are. Are you a liar, a cheater, one of these lawsuit lottery people trying to make a buck, or are you really a real victim, really serious injury victim, who's true and authentic? So they want to do all that, but it depends also on how much you're looking for. If you're looking for a quick settlement, you could probably get one without doing the deposition. And Rain and Dream says, what's the average or what's the settlement range for TLIF surgery for New York City construction accident? Yeah, I mean, TLIF, that's pretty serious. That's going to be the fusion type surgery, right? So I would say for construction, if it's just the fusion, with construction, it's not just the fusion, it's also lost wages, and the wages are high because the construction workers, they get a lot of benefits. So those usually are good, anywhere from 3-4 million, even up to higher, it could even be 7 million, 10 million. Those could be very high. I can run it for you. Just text me and give me a little bit of the details of what happened, or we can do a consult call. And then Buckshot says, will a car insurance company be concerned about setting a precedent? In any scenario, will an insurance company fight a case to avoid establishing a precedent? What does that even mean? So a precedent is just like a decision, like when you set a precedent, for example, before schools were segregated, right? And then Brown versus Board of Education, that was a case from the Supreme Court where they said, no, schools have to be integrated, right? And that was the precedent. So that's an example of a precedent. So precedent is just anything that sets a new law, like a decision from the court. It's known as stare decisis, right? It's precedential law. They make a decision. And then when you get a decision, then you rely on that decision, and then other courts in the future are going to cite to that decision, cite to that precedent. So a car insurance company I don't know why they would be concerned about setting a precedent, unless they mean not in a legal sense, but for example, if you're asking them to pay you, I don't know, $1 million for a stubbed toe, and they might say, well, we don't want to set that precedent, because if they give you $1 million for a stubbed toe, guess what? Everyone's going to say, hey, now give me $1 million for a stubbed toe, right? So maybe that's what they mean, but I'm not really sure. But usually they don't really fight a case to avoid setting a precedent. They usually just fight a case because they want to save their money, and unless they see that the plaintiff's attorney is strong and they're a real trial attorney and they're going to make them pay. And if they don't pay X, then guess what? If they go to court, they're going to pay 10X, right? So then so that's usually how they think. I don't think it's really about setting precedents. Okay, and then inspired, oh wow, we have a lot of questions. I'm gonna have to get to some of these later because I have to run. But inspired seeker says, hello Arkady, defense is asking for a deposition in my New York car crash. Had a meniscus repair, a lumbar discectomy, multiple epidurals, nearly 12 months of PT. Do cases usually settle after this step? Yeah, like we talked about today, absolutely. Cases usually settle after depositions, and that sounds like a good case. Yeah, if you have a discectomy, epidurals, that's a strong case. Yeah, feel free to text me as well, 347-566-9595. I'm happy to chat and give you some good advice, confidential, and it's free. What you could be looking for in terms of a settlement for that? I mean, if it's a discectomy, I think somebody else asked that today. Laminectomy, discectomy. It could be if it's a full-blown, meaning a full discectomy. Even percutaneous. Percutaneous discectomy is considered minimally invasive surgery, maybe like $500,000, But a full, complete discectomy, if that's what it was, that could be even $1 million, 1.5, 1.1. It's hard to say exactly, but definitely could be substantial. And Combi says, I got a 150 settlement offer. The policy was 250. I denied it, and my trial is scheduled for August. Do you notice most multi-7-figure cases get settled pre-trial? Well, 7 figures would be millions, right? If it's 150 or 250, that's 6 figures. But yeah, they settle pre-trial. I mean, if they offered you 150, but the policy is only 250, there's only another 100,000 you can get. They'll probably kick it up a bit when you pick a jury. And Daniel says, love your videos. I was hit on my motorcycle when someone changed lanes into me on the freeway, broken clavicle, arm with plates in both, and panic attacks. How much do you think my case is worth? I mean, as long as they have insurance, whoever hit you, it could be worth a lot. With a broken clavicle, I actually did a trial with a broken clavicle. I think we got about 250. We got about 150 for the injury, and then another 100 because there was like a unrealized occupation because the guy was studying to be an economist or a bookkeeper, an accountant, and then he couldn't, do that job because he had a broken clavicle. He couldn't finish school, he couldn't write, and I think we got money for his economics, like his lost wages, unrealized occupation, as well as for his pain himself. And altogether, it was about 250 in that case. So yeah, something like that. It could be even bigger, depending on how serious the overall impact and how permanent the overall impact is to your life. And here's a question. I got rear-ended by a big truck, commercial, but still in pain. You finished your discovery. What's next? The case is in court already. Well, if you finish discovery, you're going to put it on the trial calendar. Then you're going to deal with mediation, pre-trial conferences, and then the trial. And Mighty K says, how long before the check is deposited after a mediation settlement? I mean, usually it's 30 days, unless they're liens, then it could be delayed, but usually like 30, 45 days. And David says, is it possible for a settlement offer at any time during the lawsuit before deposition? Yeah, absolutely. A settlement can happen at any time, meaning even before a lawsuit is filed. Like my friend, who I think I talked about this before, and actually one of my cases, I gave it to, it was in another state, and I gave it to one of my friends who's like a really good trial attorney. And as soon as the insurance company and the defense lawyer, because they were actually working on another case. I didn't know that. They were already working on another case. And then they got this case. I'm like, oh, it's you guys again. We have this case with you. So as soon as they saw who it was, right, that I referred it was actually a YouTube viewer. I referred the YouTube viewer to this firm. They just said, look, we have, I forgot, I think it was like $3 million that they had in insurance. Said, look, just take all our money, take the $3 million. They didn't want to deal with these people because they knew like how good these lawyers were, and they thought like if we fight with them, we would end up paying more plus the legal fees. So they just paid everything, and nothing was done. There wasn't even a lawsuit filed. So a case could settle at any time. And Sasha says, thank you, Arkady. You're very welcome. Diego says, in Texas, if my personal injury attorney is facing multiple problems that could potentially affect his performance on my case, what should I do? And is he legally bound to make me aware of this? I mean, he is, but he might not, because he doesn't want to admit that. But I mean, it's hard to say what you should do. You could consult with it if you're not happy with him. If you think there's some kind of problems, you could consult with a different attorney. It's your right. Just like, you go to one doctor, you like the doctor, you're like, yeah, I'm not sure. Then you go to another doctor, and the second doctor, you're like, oh, wow, I love this doctor. This doctor is, the shiznit or whatever. This doctor is the best. And then you stay with the second doctor. So that's fine. It's your right to do that. It's just like I have a Pepsi today. Tomorrow I'm going to want a Coke. It's free. It's America. And you don't have to stay with somebody you're not happy with. Okay, let me try to get through these questions because I have to run. Daniel says, during a stressful time waiting on a case, your videos are calming. Learning more about the process really helps. Oh, thank you so much. That's what it's all about. Come along with Uncle Joe says, super attorney, thank you. Oh, you're very welcome. And Mr. Halloween, floor collapse on construction. One guy died, and there's a criminal investigation. Also, I was hurt there. I was also many times questioned from the DEA office. Oh, wow. So that's a good case. Yeah, feel free to text me. I'm happy to chat with you about that. And remember, it's a confidential meeting. I won't tell anybody because we have attorney-client privilege. Whether it's your lawyer or anyone else, nobody finds out. I'm happy to give you some insight. And then Mighty K says, thank you, Arkady. You are the man. Truly helped and answered a ton of mind-boggling questions. Oh, thank you so much. And then Rain and Dream says, can you repeat your number, please? Yeah, absolutely. Let me drop it in the chat as well. It's 347-566-9595. Yeah, you can just text me. If you text me, just text me like, your name, briefly what happened, like the facts, just with 1 or 2 sentences so I can see it happening in my head, whether it's a car crash, like a rear end, whatever it is. And then your injuries, your city, and the date of incident. And that's about it. That's really all I need. Just really, the whole thing could be really short, just 2 or 3 lines. And John says, so if an attorney sends bad faith letter and demands policy max ASAP, how long do they really have to reply in New Jersey? I mean, usually I put 30 days in the letter, but if they're really gonna give you an offer in good faith and they ask for an extension, 60 days, you can give it to them. And then Daniel says open policy. Yeah, you can open something. Open policy. And Brooklyn says, have you ever sued U-Haul? I have injuries, but I was also in an accident last year. Yeah, no, I have. I've had cases with U-Haul. And Luciano says, I'm in Texas. In a wreck, driver admitted fault, as did the insurance company. Is that normal that my attorney still doesn't know the coverage? Well, he should file a lawsuit and then just ask for that in discovery, and then they'll just tell him the coverage. In some states, if you do it pre-suit, they just don't tell you because they don't have to. Like I think in New Jersey, it's like that. In New York, they do have to tell you, even pre-suit, without filing a lawsuit. But in New Jersey, they don't have to. So if you call them and say, well, we don't have to tell you, that's our law. So then you just file a lawsuit. It takes literally 15, maybe less than 15 minutes. You press a button, everything merges. You get a lawsuit, you file it in court. Now you're in court, you just serve a discovery demand, give me your insurance information, and they give it to you. So you can still find out. And Mr. Halloween says, I will text you. Thank you very much. Best attorney. Oh, you're very welcome. Thank you. And then he says, yes, we have an adjuster. So this week should be more news. Thank you so much. Oh, you're very welcome. Okay, thank you, everyone. I have to run, but this was great. Thank you so much. Please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is to help serious injury victims and families. All the best, everyone. Bye.